I would like to read an opening statement. This is to advise the general public that in compliance with Chapter 231 of the Public Laws of 1975, entitled the Senator Byron M. Bear Open Public Meeting Act, New Jersey Casino Control Commission on September 15, 2021, filed with Secretary of State at the State House in Trenton a notice of this hearing. On September 15, 2021, copies were mailed to subscribers. Any member of the public who wishes to address the commission will be given the opportunity to do so before the commission adjourns for the day. Please acknowledge the Pledge of Allegiance.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Good morning. Welcome, everyone who is joining us remotely today as a measure to mitigate the spread of COVID-19 and to protect the health and safety of meeting participants, as well as members of the public interested in the meeting today. The Commission is continuing to use remote collaboration technology for meeting participants. The public is able to listen through access provided on the Commission's website, as well as through our YouTube channel. We will accept public comments via email. Public comments can be sent to public.comments@ccc.state.nj.us. I will repeat that website. public.comments@ccc.state.nj.us, beginning now and any time throughout the meeting, ending at the time of the adjournment of the meeting. This meeting is being transcribed as well as recorded, and minutes will be available on our website in due course. To meeting callers, I ask that you follow the instructions provided with the web link or the audio call-in code, and place your phones on mute until your matter is called. Also, please remember to identify yourself before speaking. Thank you.
Thank you and good morning. Please answer when I call your name for the record, please. Commissioner Molyneux,
Present.
Vice Chair Cooper,
Present.
and Chairman Pelosi.
Present.
Mr. Chairman, with your permission, may I call out of order the special agenda and move to item number 3 for your consideration. First is the joint petition of Bally's Corporation and Premier Entertainment AC LLC, requesting permission for 3 officers to assume the duties and exercise the powers of their respective positions pending qualification. This matter comes to you by way of a petition that was filed on September 15, 2021, requesting the temporary qualification of Lee Fenton to serve as Director and Chief Executive Officer, Bally's Corporation, Robeson Reeves, Chief Operating Officer, Bally's Corporation, and James Ryan, Director, Bally's Corporation. I believe counsel is present and can address the matter directly.
Yes, thank you, Lynn Kaufman, Cooper Levinson, on behalf of Bally's Corporation. Thank you, commissioners. This matter is before you in anticipation of the upcoming transaction between Bally's Corporation and GameSys. As General Counsel stated, these 3 gentlemen wish to assume the offices and be temporarily qualified upon the closing of the transaction, which will be occurring, everybody hopes, within the next few weeks at the most. Thank you.
Thank you, Division.
Good morning, Chairman and Commissioners. I believe my colleague, Deputy Attorney General Alessandra Baldini, is on the line. Ali, are you connected? She might be having some technical difficulties, but I'm happy to respond for the division. The division has reviewed the petition, and you have the division's responses dated September 20th and September 21st of no objection to the requested relief. At this time, as no draft circulation has been circulated, the division reserves its position as to that and will provide comments on that resolution when it is circulated. Thank you very much.
Thank you, Mr. Hollander. Any questions for council?
We're just confirming that Jordan Hollander's name is reflected in the record.
Hearing no questions.
Yes, sorry. For appearance, Jordan Hollander, Deputy Attorney General, on behalf of the Division of Gaming Enforcement.
Thank you.
Thank you.
Again, are there any questions for council? No. Hearing none, is there a motion?
Mr. Chairman, I move to adopt the draft resolution and authorize, on a temporary basis and prior to plenary qualification, the following officers to assume the duties and exercise the powers of their respective positions for Bally's Corporation in accordance with the conditions contained in NJSA 5:12-85.1C, NJSA 5:12-89B 1 and 2, and NJAC 13:69C-2.7 with regard to Mr. Lee Fenton, the Director and Chief Executive Officer.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion? Hearing none, roll call vote.
Commissioner Molyneux,
Yes.
Vice Chair Cooper,
Yes.
and Chairman Levinson. Chairman Pelosi, I went way back to 2012.
Yes.
Chairman Pelosi.
Yes.
With respect to Robertson Reeves, Chief Operating Officer.
Is there a motion?
I'll make the motion, Mr. Chairman.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion? Hearing none, roll call vote.
Commissioner Molyneux,
Yes.
Vice Chair Cooper,
Yes.
and Chairman Pelosi.
Yes.
With respect to James Ryan as Director.
Is there a motion?
Mr. Chairman, I'll make the motion.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion? Hearing none, roll call vote.
Commissioner Molyneux,
Yes.
and Vice Chair Cooper,
Yes.
and Chairman Pelosi.
Yes.
Thank you. Now we will return to agenda item number 1 and 2 are connected, but we will call them separately, Mr. Chairman. The first is the joint petition of OCRM LLC and AC Ocean Walk LLC for approval of a management agreement, PRN 2252101. This matter comes before you by way of a joint petition that was filed on August 13, 2021, seeking approval of a management agreement between OCRM and AC Ocean. Again, council is present on that matter, and I ask that they put their appearances on the record and proceed.
Thank you. Lynn Kaufman, Cooper Levinson, on behalf of OCRM LLC.
Thank you.
Good morning, Chairman and Commissioners. Sarah Ben David, Deputy Attorney General, appearing on behalf of the Division of Gaming Enforcement.
And good morning, Chair Pelosi, Vice Chair Cooper, and Commissioner Molyneux. Stephen D. Schreier with the law firm of Blank Rome on behalf of the joint petitioner, AC Ocean Walk LLC, doing business as Ocean Casino Resort.
Thank you. Before we begin arguments, I understand there are several exhibits that have been pre-marked. Mr. Nance, can you identify them for the record?
Yes, Chair, Commissioners, the pre-marked exhibits are as follows. The petitioner submitted one exhibit, pre-marked as P1. P1 is the draft management agreement between OCRM LLC and AC Ocean Walk LLC. Division of Gaming Enforcement submitted one exhibit, pre-marked as D1. D1 is a report to the Casino Control Commission dated September 8, 2021, on the joint petition of OCRM LLC and AC Ocean Walk LLC for approval of a management agreement and petition of OCRM LLC for a determination of status as a casino service industry enterprise, petition number 2252101, and petition number 0621601.
I also understand there's a sealing request pending for P1. Does council want to be heard on the sealing request and the admission of the exhibits into the record? Ms. Goffman?
I have reviewed the draft resolution of the commission, and I have no objections and have nothing to offer in addition to that. Thank you.
Thank you. Division?
The division does have an objection to the draft resolution that was circulated, and as much as it provides for the sealing request to be addressed after today's proceeding. As you know, requests for sealing are to be resolved by the parties in advance of a proceeding so that the documents at issue can be entered into evidence at the time of important casino licensure proceedings held before the commission. In this case, council's not submitted a request for sealing of the division's report or the management agreement in advance. She's advocated instead for the commission to approve the management agreement without those key documents and evidence and available to the public as required by the act and regulations, and to have the sealing decided later. In the division's view, there is a process and it should be respected. The proposed approach is not respectful of the requisite process, the commission, the division, and the public. Under Section 82 of the Casino Control Act, the commission is statutorily required to consider and act upon all agreements for the management of a casino because management agreements are critical matters that should be reviewed and approved at a proceeding in full view of the public. There's a public right to know in the context of this proceeding and rulings, and the availability of the management agreement is essential to both the approval of the agreement and the status designation of the proposed casino manager. Council's proposal to have the commission approve the management agreement without having the actual agreement in a form available to the public does not provide for the transparency contemplated by the act. Hence the division's objection. Thank you.
Thank you. Duly noted by the commission.
Mr. Chairman,
Yes.
I would indicate for the record that staff has been privy to those discussions with respect to the sealing issue, and the draft that council represents was circulated pre those discussions. Staff recommends that in light of those discussions that took place post the submission of the draft resolution, that the commission consider the alternative, which is that D1, which is the division's report, be fully admitted into the record unredacted, and that with respect to P1, the management agreement, that petitioners have until Thursday to submit a written sealing request, and the division be allowed to respond in writing to that sealing request by Monday, and that the resolution reflect that the authority is delegated to you on behalf of the commission to review those submissions and make an ultimate determination with regard to the management agreement sealing request.
Thank you.
Chair, may I respectfully address the commission?
The floor is yours, Ms. Kaufman.
Yes. First of all, we agree, do not object to the submission of the division's report. Also, we would like to add to the importance of transparency and public having access to all important information that is necessary. Obviously, we respect the regulatory process and the statute, and we are not suggesting that that does not happen. In accordance with precedent, as recently as last week, the commission has deferred matters of sealing to a later time. In this case, while the management agreement may be approved today, the management agreement is not going to be going into effect until after the ICA hearing and after the qualification of OCRM. Therefore, there will actually be not only an opportunity for this matter to be resolved after this hearing, but there is going to be another public hearing where we will be discussing the entire transaction and where the management agreement fits into that transaction. And we respectfully submit that at that time, the public will actually have a better picture of what actually, how things will operate, and will have transparency in the fullest sense. So just wanted to respectfully make those comments. Thank you.
Thank you.
May I be heard as well, Commissioner, or Mr. Chairman? Thank you. I would support what Ms. Kaufman has just identified in terms of her position on behalf of the joint petitioner. And I also support the staff's recommendation regarding how to resolve the situation in a very short period of time pertaining to proposed sealing of the management agreement. I think it's important that we get this right, whatever amount of time it might take, and notwithstanding when requests were made or how they're made, I think requests could be made appropriately even at this hearing for the commission's consideration. So I just think here we have a countervailing policy decision between the transparency and importance of the management agreement under the Act, as well as Section 74.1 of the Act, protects information that's provided confidentially to the commission and the division. And I think, having that process done as quickly as possible benefits all parties, including the public. Thank you.
And I also do not object to the shortened period of time to resolve the sealing issue. I think that will be in everyone's best interest.
Thank you.
Chairman, may I be heard again?
Yes.
Thank you. Just wanted to address the point raised by Ms. Kaufman regarding the handling of prior matters and the precedent that had been set. I'm familiar with the situation with resorts, but I would just like to make the point that that situation seems distinguishable. And that proceeding, it's my understanding that the entire agreement had been made public for a very long time, which is not really the case under the proposal that Ms. Kaufman is making here, which is to have the agreement just withheld entirely from these proceedings and to have sealing addressed later. But as to the offer that was set forth by Ms. Fauntleroy to have sealing addressed within a short period of time of 2 days for Ms. Kaufman to make the request, and then a subsequent 2 days to have it, responded to by the division, we would not object to that framework given it's a short period of time. Thank you.
Thank you. Duly noted. Commissioners, do you have any questions regarding the sealing request of the exhibits?
I do, Mr. Chairman.
Yes.
Addressed to the, addressed as the taking of, why it's taking so long and why you weren't prepared at this particular time.
I presume that's, Commissioner, that's addressed to me. As I had indicated, I had a matter last week which Deputy Attorney General and I disagree on why that was permitted to be handled at a later time, but it seemed to make sense to me, particularly because there were some general issues regarding information in a management agreement that perhaps could be considered to be proprietary or not and was up to debate. It all seemed to make sense to me, especially because we are not going to be managing or operating the casino or have any right to be involved in Ocean yet, to have that matter also resolved after the hearing and perhaps have certain things be a consistent approach by the commission. It was not that there was any was not being lax and not respecting the process. It was a decision that made sense certainly to me and my client.
Thank you.
Thank you. Any further questions? If there's nothing further, I move Exhibits P1 and D1 in the evidence, subject to final decision on the petitioner's sealing request with respect to P1. Is there a second?
Mr. Chairman, I'll second that.
Any further discussion? Hearing none, all in favor say aye. Aye. Opposed? Ayes have it. We can now hear your presentations on this matter. Ms. Kaufman, please begin.
Yes, thank you, Chair. As you're aware, last week you approved a structure to facilitate an investment by OCR Investment LLC indirectly into AC Ocean Walk LLC, the casino licensee known as Ocean. The matters before you today are the next step before we have what I had just discussed, which is the full ICA hearing, after which time, if qualified and the ICA is approved, at which time the transaction will occur and the investment will be made, and pending resolution of today, the OCRM will begin to manage the property. In the first petition before you today, we have the approval of the management agreement for OCRM to do so. There are specific requirements under the Casino Control Act in order for an agreement to be approved as a management agreement. We submit that the management agreement before you today meets those criteria. And I will quickly run through the criteria, although they are set forth in the petition before you today. The party who is going to be managing the casino needs to either hold a casino license or a CSIE license, or is an applicant therefore. We'll address that more specifically for the next matter. However, as you know, we are requesting a CSIE. We'll also point out that an affiliate of OCRM is being qualified as a holding company under a casino license of Ocean, and the individual qualifiers of OCRM are also being qualified as qualifiers under the casino license of Ocean. The next criteria is that the manager must own 10% or more of the equity of the casino licensee. In this instance, an affiliate of the manager will own considerably more than 10% of the equity interest in Ocean. The management agreement must be for the complete management of casino space and must provide the sole and unrestricted power to direct gaming operations in the hands of the manager. That, as pointed out in the petition, has occurred. The management agreement also must be for a sufficient durational time to ensure stability and success of the casino licensee. In this instance, we will state that while the initial durational period is for a shorter period of time than other management agreements, there are two much longer renewal periods. And unlike other management agreements, there is a much higher percentage of equity interest in the casino licensee. So by virtue of that equity interest, there is a built-in desire for the casino to succeed. Lastly, the agreement must provide for joint and several liability between the casino licensee and the manager, and the proposed management agreement does have that required language. Therefore, we would respectfully request the commission to approve the form of management agreement.
Thank you.
Mr. Chairman,
Yes,
may I be heard?
proceed.
Thank you. First, I want to thank you all for holding this special meeting today. We do appreciate that. I join in Ms. Kaufman's position as she presented on behalf of the co-petitioner. I believe that the management agreement does comply with the Act, Section 82C, as outlined by Ms. Kaufman. I've also reviewed the division's report, and I believe that that report also summarizes how those criteria have been met by the management agreement. And I would ask that you approve the management agreement today. Thank you.
Division?
Good morning again, Chairman and Commissioners. Sarah Ben David on behalf of the division. The petitioners are seeking approval of a management agreement between OCRM LLC and casino licensee AC Ocean Walk LLC. OCRM LLC is wholly owned by trusts established for the benefit of the descendants of Marion Ilitch. As you know, the same trusts own OCR Investment LLC, which is planning to make a two-phase investment in the Ocean casino operation. The Casino Control Act sets forth certain requirements for a management agreement, which Ms. Kaufman has reviewed, so I won't repeat them. But as has been indicated, AC Ocean Walk LLC holds a casino license. The commission will determine today if OCRM LLC should hold either a casino license or CSIE license. OCRM LLC does not own at least 10% of the equity securities of AC Ocean, which is a requirement of the Act. However, the division's view is that the purpose of the requirement is satisfied under the circumstances presented, where the owner of OCRM LLC will also hold a significant indirect interest in AC Ocean, as indicated by Ms. Kaufman. The agreement is for the complete management of the casino. As to duration, the initial term is only 2 years. However, in the division's view, other provisions in the agreement, and again, the relationship between the parties provide adequate assurance of continuity, stability, and independence in management as required by the Act. Finally, each party is jointly and severally liable for all acts, omissions, and violations of the Act. Therefore, the division recommends that the commission approve the management agreement subject to the conditions outlined in the division's letter report, which was filed on September 8th, 2021. Thank you.
Thank you. Commissioners, are there any questions for council? Council, is there any further items to be added? Hearing none. As we heard from council today, AC Ocean Walk, doing business as Ocean Casino, and OCRM LLC seek approval of a proposed management agreement between them. The Casino Control Act provides that every agreement for the management of a casino must be in writing, include certain mandatory components, and be approved by the commission. The Act further directs the commission to require the following with respect to the casino management agreements. that each party to the agreement hold a casino license or a casino service industry enterprise license, that a casino manager owns at least 10% of the casino licensee's equity securities, that the management agreement be for the complete management of all casino space and provide for sole and unrestricted power to direct casino gaming operations, that the agreement be for a long enough term that ensures reasonable continuity, stability, and independence in the management of gaming operations, and lastly, that each party to the agreement be jointly and individually liable for all acts, omissions, and violations of the Casino Control Act by either party to the agreement regardless of the knowledge of the act, omission, or violation, or any provision in the agreement to the contrary. In this case, each party to the OCRM and Ocean Management Agreement will be licensed. We will consider and decide the issue of the appropriate licensure for OCRM as our next agenda item. OCRM is an affiliate and sister subsidiary of OCR Investment, which is an applicant for an interim casino authorization. And through its framework and investment agreement with AC Ocean, own 32.4% and up to potentially 50% of AC Ocean's holding company. The purpose of requiring at least a 10% ownership interest is so that the commission can be assured that the casino manager has a vested financial interest in the success of the casino operations and ties that success to the manager's performance. Here, the commonality of the interest between OCRM and AC Ocean is significant and supports a finding that the 10% ownership interest requirement has been met. The management agreement is for the complete management of Ocean and provides OCRM with the authority to direct casino operations for an initial period of 2 years. The agreement is automatically extended for 2 terms of 5 years each unless either party gives 90 days prior written notice of its intent not to extend the agreement. 2 years is relatively a short initial term. The purpose of this requirement, as noted in the Act, is to ensure continuity, stability, and independence in casino operations. Notably, OCRM does not intend to replace any of AC Ocean's current executive team. Additionally, the management agreement includes a number of provisions that ensure continuity of operations should the agreement not be extended. Further, as noted, the planned ownership interest in Ocean provides a sufficient incentive to ensure a seamless transition should the management agreement not be extended. Lastly, the agreement appropriately requires that each party will be jointly and individually liable as mandated. In my opinion, petitioners have provided the Commission with the management agreement that complies with the requirement of Section 82C of the Act and warrants our approval. Are there any additional questions or comments? Hearing none, is there a motion on this matter?
Mr. Chairman, I move to adopt the draft resolution and approve the management agreement and find, A, the draft management agreement complies with the requirements in NJSA 5:12-82C 7 and 10 of the Act, and B, the draft management agreement includes within its terms all provisions reasonably necessary to best accomplish the policies of the Act in accordance with NJSA 5:12-82C, based upon and to the extent set forth in the findings and rulings and subject to the conditions contained in the resolution.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion? Hearing none, all in favor say aye. Aye. Opposed? Ayes have it.
Thank you.
Thank you.
The next item for your consideration is the companion matter, which is the petition of OCRM LLC for a determination of status as a casino service industry enterprise, PRN 2292102. Again, this matter is related to the item you just resolved. The petition seeking this particular determination was filed on August 17, 2021. Same council are here to proceed. However, this is not a joint petition. It is the petition of OCRM.
Thank you. Lynn Kaufman again, and I believe my partner Lloyd Levinson also Navy here. I just want to recognize that, thank him for his assistance here. This matter, as described, is for a determination of licensure status of OCRM. Specifically, OCRM is requesting a determination that it holds a casino service industry enterprise license instead of a casino license pursuant to Section 82(7) of the Act. While the agreement shows the requisite control to be a management agreement under the Casino Control Act, as the division pointed out in its report, its control is not unfettered, and as a matter of fact, there are 23 separate areas where their OCRM must either consult or seek approval of Ocean before making a final determination. The all the employees will remain employees of Ocean, and the general manager of Ocean will continue in a CEO position. The Act provides for a CSIE in certain instances, and we purport that, as stated in the papers and as the division detailed in its report, that this is an appropriate and required, perhaps, occasion to have a CSIE license be issued instead of a casino license. I again point out that the qualifiers of OCRM are being qualified as qualifiers of a casino licensee in connection with OCR investments, and they're not being qualified to the standard, although it is the same standard under the CSIE set of regulations and area. Thank you.
Division?
Sarah Ben David, again, appearing on behalf of the Division of Gaming Enforcement. As has been reviewed on the prior item, as well as by Ms. Kaufman on this item, the Casino Control Act requires the manager of a casino to hold either a casino service industry enterprise license or a casino license. The division has reviewed the authority of OCRM LLC under the management agreement, and the division finds OCRM LLC's control will not be unfettered in several important areas, as reviewed by Ms. Kaufman. I believe there's 23 of them, including matters related to personnel, financial controls, and casino operations. In these areas, OCRM LLC is often required to consult with and obtain the prior approval of AC Ocean Walk LLC. On September 8th, 2021, the division filed a letter report regarding this matter. Based on the consultation and pre-approval rights retained by AC Ocean Walk LLC, the division believes it would be appropriate for OCRM LLC to seek licensure as a CSIE rather than casino licensure. Thank you.
I
Mr.
want to note
Chairman.
for the record that P1 and D1 are also relevant to this matter, and since both have been already admitted into evidence in the sealing request, with respect to P1 to be addressed by delegated authority to me, we do not need to repeat that step here. So I just want to add that into the record. Commissioners, do you have any questions for either council?
No.
No, satisfied. Thank you.
Okay. By separate petition, OCRM LLC seeks a ruling from the commission that it should be licensed as a casino service industry enterprise, not a casino licensee, in connection with its now approved management agreement with AC Ocean. As noted by the parties in their filings, a 2011 amendment to Section 82C of the Act provided that the Commission with the discretion to require a party to a casino management agreement to hold either a casino license or a casino service industry enterprise license. The amendment gives us greater flexibility to address the ever-changing gaming environment, but it still ensures that we have the necessary regulatory tools to maintain integrity within our gaming industry. I am satisfied based on the specifics of this matter, including the arguments of the council, the information contained in the petition, the division's report and recommendations, and the terms of the management agreement, and in light of the upcoming consideration of the OCR investment petition for an ICA, that this is an instance where the casino service industry enterprise license is appropriate, and that the OCRM request, subject to a number of conditions, should be granted. OCRM, as manager of Ocean, will have control over Ocean's casinos operations as required for the approval of the management agreement. However, that control is not limited in a number of important and sensitive areas. The prior approval of and/or consultation with AC Ocean is required in critical areas such as personnel decisions, financial controls, and casino operations. Further, the division has reviewed the filings extensively and has recommended, subject to several conditions, that the Commission grant OCRM's request. I'm satisfied that the proposed conditions are not only appropriate, but necessary to ensure that the regulatory authorities remain informed on the ongoing basis of the real-time impact of the implementation of the management agreement. With that being said, are there any further questions or comments? Hearing none, is there a motion on this matter?
Mr. Chairman, I move to adopt the draft resolution and grant the requested relief and find that A, pursuant to NJSA 5:12-82C, number 7, OCRM LLC is eligible for and is required to obtain a casino service industry enterprise license pursuant to NJSA 5:12-92A in connection with its management agreement with AC Ocean Walk LLC. And B, OCRM LLC shall not be required to obtain a casino license in connection with its management agreement with AC Ocean Walk LLC, based upon and to the extent set forth in the findings and rulings and subject to the conditions contained in the resolution.
Is there a second?
Mr. Chairman, I second the motion.
Any further discussion? Hearing none, roll call vote.
Commissioner Maldonado?
Yes.
Vice Chair Cooper?
Yes.
And Chairman Pelosi?
Yes. Thank you. Yeah.
Thank you, Commissioners. May I just say that OCR Investment and OCRM are very excited that they're in the home stretch. As you know, they had started discussions with Luxor before the pandemic, and we're happy to say that we're all still here and in the home stretch, and they're looking forward to becoming part of the Atlantic City landscape. Thank the commission and the division for their cooperation and help in getting us where we are now. So thank you.
Thank you for those kind words.
I would second that, Mr. Chairman, members of the commission division. All may have thought that I disappeared, but I've been here the entire time. Thank you.
Mr. Levinson.
And Mr. Chairman, in accordance with Resolution 2012-0903, the next closed session will be held on Wednesday, October 13, 2021, at 9:30 a.m. in the commission offices.
This is the public participation portion of the meeting. Ms. Fauntleroy, do we have any comments?
Mr. Chairman, no, we do not.
Public participation portion of the meeting is now closed. Can I have a motion for adjournment?
Mr. Chairman, I'll make the motion.
Do I have a second?
Mr. Chairman, I second the motion.
All in favor, say aye.
Aye.
Opposed? Ayes have it. Meeting is now adjourned. Thank you.